5 minutes. And we're ready to proceed, and just wanted to clarify a couple points. We are videotaping. It will be, uploaded on YouTube. And so especially with these kids' cases, we're trying to make sure that everybody remembers that we don't mention children's minors' names. Okay? Either their initials or just refer to it as the child. Ready to proceed?
Yes, Your Honor.
Yes, Your Honor. Let's go. Thank you. All you do, let me know if you want to reserve time too, please.
Okay. I don't think that'll be a problem in this case.
All right, that's fine. Thank you.
May it please the court, my name is Denise Ferguson, and I'm here to represent Father Matthew Wassam. Now, this is a relatively simplistic case. We're here strictly on the consent portion of whether or not my client has to consent to the adoption of his daughter to the stepfather. The stepfather had filed for adoption on Valentine's Day of 2017. The stepfather is married to the mother of the child, the biological mother. My client is incarcerated in Belmont Correctional Facility. He has had contact with the child, phone calls, and I believe a few visits or so when his parents would take the child down to see him. He's also done like Skype calls and so on and so forth. So this was strictly regarding child support and whether or not he had paid more than de minimis. Now, child support is something that the statute says you cannot impute income to someone that's serving more than a year at a state correctional institute. He did have a child support order. He was working at the prison. The issue with his job was he was only earning $12 a month. 25% of his income every month was deducted from his pay by a child support enforcement agency. He had 2 support orders. Child support enforcement determined who would get said money. Mother testified that she received $12.23 out of his payments over a year.
The 1 year preceding the filing of the adoption? Or?
Yes. Well, the adoption has not been filed yet.
I meant
finalized. I'm sorry.
Filing.
Yes, before it was filed. She had received $12.23. He earned $12 a month. The court took into consideration the fact that his parents provided him with funds in which to purchase personal items such as soap, deodorant, t-shirts, clothing, that sort of thing that he can use while he's in prison. The interesting part is mother also gifted father with funds in his prison account. She sent him money. And then ironically, she stated that she didn't receive enough money from him, even though she had sent him money through his prison account in order to get stamps and write to his daughter.
Counsel, is there anything in the record that demonstrates when the $3 withholding was set up? You said there were 2 child support orders. So
Yes.
for this child as well as the first child. So was that one already, set up for deduction before he entered prison, do you know? Or?
I am not quite sure about that, Your Honor. I did not find a specific start date for that in the record.
All right, thank you.
And I don't want to misspeak. It could be in there. I did not see it, however. Now, it does state that the way to calculate child support, I'm sure you're all familiar with, is that they take into consideration income. They don't deal with gifts or unsustainable money that you can't guarantee is coming. The grandparents, father's parents, were gifting him with money. That did not mean that that was within his control or that he could guarantee that he was going to get those funds every month. So therefore, that should not have been taken into consideration when it came to stating that father had enough income in which to pay his child support, because that was not a guaranteed sum. Father could have worked his way up through the prison system into higher jobs, except for the fact that he had issues with his ankle. He could not walk or bend or do a lot of things for any limited amount of time, so he could not progress and move higher up on the hierarchy to earn more money. He was restricted to the $12 a month job, which basically meant he cleaned his cell, he kept his bed tidy, he washed his toilet, those sorts of things. We would ask that because the money was not, the money that was put into his prison account was not something he could count on, that it should not have qualified. This was a father that was trying to keep in touch with his child. We're not making excuses as to why he ended up there. And the record was not too clear on why he was there, but nothing was mentioned that it had anything to do with the child. Which I believe if it would have had, and maybe this is a bad assumption on my part, that they would have brought that out at the trial, that father's in prison due to something dealing with the child. But that was not mentioned in the record either. Father had been in prison for 20 months. He still had 16 months remaining at the time of the trial in August of 2017 in October. He appeared by video. He presented himself rather well in that he explained why he could not earn more money and what things cost him in prison. We would just ask that you find that his consent is necessary because he had paid $12.23 to the mother of the child, and he was in contact with the child. While $12.23 in the outside world is not a lot of money, when you're only earning $12 a month and you have 2 child support orders, that should be seen as a percentage, and therefore that higher percentage of his income was going to his child and it should not be considered de minimis. Thank you.
Counsel, before you step away, what evidence was there, if any, as to how many of the 20 months that he was in prison, he was gifted a sum from his parents?
He was gifted frequently. I'm not sure what frequently meant. It may have been every month, but they were differing amounts. It was not always the same amount. And again, I don't want to mislead the court. The record is not completely 100% clear, and I was not trial counsel. So I have to only go by what was there and not, outside discussions or something of that nature.
Welcome to our world. Thank you.
Thank you.
May I proceed, Your Honor?
Yes, please.
May it please the court, counsel. My name is Attorney Rachel Smith. I'm appearing on behalf of Attorney Kurthover 6. I represent the petitioners in this case. The evidence that was presented at trial proved by clear and convincing evidence that father failed to support his minor child. As noted in our brief, that the standard of review is by abuse of discretion. Father had a child support obligation of $50 per month. There was one payment that was established in May 2016 in the amount of $12.23. That payment was merely because of a interception of a tax refund.
Let me ask you a question in regard to that. Is it the amount that bothers you, or is it the fact that it's a tax intercept? In other words, let's say father was not in prison and was earning $50,000 a year, and he was not paying regular child support, but mom got a $2,500 check.
The court looks at the totality of the financial circumstances, so they look at not only income from a regular earning job, or the court has even found in some circumstances when somebody has no job and zero income, that a parent still has the obligation to support their child. So the financial overview in this case is that yes, he earned $12 a month through his position as a porter.
Counsel, I guess my question was, are you saying the fact that a IRS intercept is utilized in order to get funds does not mean that he has paid any child support? Are you saying that that doesn't count?
No.
Or is it the amount, because of the small amount?
I'm not saying that it's either that it came from a tax refund or it's a small amount. I'm saying that that was one payment and it wasn't, well, I guess I kind of am, because it's not like he made the proactive steps to contact child support and say, take $12 out of my child support obligation because I haven't been able to pay or I haven't been able to pay.
Was there anything in regard as to how the first
first child is a child that is not of this relationship.
Yeah, I understand that.
I believe he's 8 or 10, something like that. So that order was set up. I don't know where it came from. I know that regularly $3 every single month out of his income was taken out of that.
I'm just wondering why if CSEA had both children and 2 child support orders, it wouldn't have done both of them instead of just one,
Yeah, I'm not entirely sure.
since it's not like he's voluntarily giving the money to begin with.
Right, but father did not contact CSA to find that out. Father's mother, the paternal grandmother in this case, actually had power of attorney for father while he was incarcerated to make financial decisions for him. He never asked his mother to contact CSA to try to figure it out. He had testified at trial that he's only able to send money out of his commissary account to people that are on an approved visitor list. He admitted that he never contacted the prison to see if he could send money out to CSEA for his child support obligation. And I think that overall, when looking at the financial picture, we have to look at the amount of these gifts that were given to him from his mother. It was between $300 to $400 a month, every single month.
Was his mother also supporting the child
No,
in any fashion?
no.
Well, I thought there was evidence that she did, that they had visitation and they bought the child food and obviously they sheltered the child when the child was staying with them.
I mean, while the child was with them, then I'm sure that they paid for her living expenses for the couple days a week
Well,
that she was there.
That's support, isn't it?
No, that's not support.
Okay. Why is it not when it's support in regard to when husband and wife have get a divorce?
Because it's support that the father had paid for or directed to be paid to the child.
I understand, but
Right.
I think Judge Hensel's question was, is there any evidence that the grandparents, the paternal grandparents supported the child?
I think that I'm confused on your interpretation of support. No money went from maternal grandparents to mother to fulfill father's child support obligation, if that makes sense.
But if father, let me ask you this, because these cases are confusing as far as I'm concerned. Let me ask you this, if father were not in prison and he had picked the child up every other weekend, bought him or her food, I'm just doing hypothetical, and kept them overnight, and provided for whatever they needed for, that would be 4 to 6 days a month, let's say, would you consider that support?
The court looks at the totality of the circumstances, so I'm sure that at that point, a child support obligation would have been set up, and the court would have determined the percentage of his parenting time versus his income versus her income, and come up with a guideline support as per the worksheet. So the facts of that situation would be totally different from the facts of this situation.
I understand, I'm just trying to figure out what is support, and what are the financial conditions and circumstances that make up support.
Right.
Because it's clearly not just if it's just not paying the actual amount each month, then that would be a clear-cut case in these cases, and the courts have not said that, have they?
It's, the courts have even said in cases, I believe that they're cited in our brief, if not, I may have read them, where, say, a father would send a $120 gift card and birthday presents and things of that nature, but he substantially failed to meet his support obligation. It's whether it's de minimis.
I understand, I'm just saying, but the rule is not that if you don't pay your $50 a month, you automatically don't have any right to consent, or
Right.
to not be able to consent to adoption.
Right, and it depends on the entire circumstances. The court looks to the income from all sources, and in this case, the most substantial income is the $300 to $400 a month that father receives from his parents. The testimony at trial was that $3 of his child support went to a child from another relationship. He spent approximately $100 in personal hygiene per month. Other than that, he had around $200 to $300 extra per month that he chose to spend on things like music, video games, pizza nights, things of that nature. So it's not only that he failed to support, and I believe that the trial court was correct in finding that a $12.23 payment for an entire year while he's $600 in arrears for child support is failure to support your child. It's whether it's done without justifiable cause. And here's
On the other
just-
hand, if you just look at his actual earnings, it's 10% of his income, the $12
for,
for 1 year.
right, okay. Yeah, but you don't look to just his income. And one thing that I did want to point out is that the the statute that opposing counsel brings up for saying that you cannot impute income for child support calculation, well, you can't, first of all. But that is for the calculation of child support. And that statute is the 3119.05. And that is for the initial calculation, putting those figures into the child support worksheet. That's where you have arguments about the imputation of income and about not being able to include non-recurring and sustainable income in a parent's income figure for the child support worksheet. That's not the case here. This child support has already been calculated and was determined to be set at $50 per month. Father never tried to modify that obligation. He never tried to contact CSEA, never tried to contact a lawyer to reach out to the courts to try to modify that obligation because he couldn't meet it. He did nothing.
So you're saying this child support order was set up before he was in prison?
It was set up shortly before because I think he was incarcerated before the final decree.
Thank you.
Another point I wanted to bring up is that opposing counsel had said that mother had gifted funds to father. She did not. She wanted to maintain contact between the minor child and father, so she contributed $10 towards the JPay account, which is another form of media for the father to be able to contact the child. The father then promptly blocked her, and the funds were sitting there at the time of trial. So that was not her giving money to him as to share her income with him for some odd reason. That was her trying to get him to contact the minor child, which she did not.
And that was within the 1-year look-back period?
Yes, I don't recall the exact date of that. So I think that in conclusion, the trial court did not abuse its discretion in finding that father did not support his child and failed in that regard, and that's the first prong of it. Second, I don't think that the trial court's decision was against the manifest best way to the evidence. And finding that there was no justifiable cause when father had an extra $200 to $300 per month that he chose to spend on his own entertainment rather than supporting his child. The Ohio Supreme Court has said that it's a difference between a parent who is unwilling but able to support and a parent who is able but unwilling to support. And I think that in this situation, the father was certainly able to support but unwilling to do so. It's for these reasons that we ask this court to uphold the trial court's decision and allow the petition to proceed.
Thank you.
Thank you.
Do I have any more?
Yes, you have 5 minutes, yes.
Okay. I just want to address a couple of points. First of all, it was stated that mother put money into father's JPay account. He never contacted her and he blocked her. There was a very good reason for that. Mother had a restraining order against father, restricting him from contacting her. Well, she went back to court in February. That judgment entry was never issued lifting the restraining order until May, and the money went into the JPay account in February. Father could have gotten in trouble for having any sort of interaction with mother, which is why he was contacting his child when his child was at his parents' house. I just want to make that very clear for this court. The other thing is, you asked a question regarding were the paternal grandparents providing anything for this child. They provided quite a bit. They were buying, they made sure this child had gifts at Christmas, birthday, special occasions. They were buying her clothes, they were buying her toys. They were doing all sorts of things, as well as providing for food and other necessities while the child was with them for visits. They weren't asking the mother to provide them with anything or anything of that nature. They were just trying to keep the relationship going. I understand that that is not income and it's not benefiting the mother in any way, but the child was benefiting from being around her father's parents. The other argument was that my client did not ask or did not go back to CSEA. He's in prison. He couldn't even get transported to court in order to try to fight to keep his rights to his daughter. To get transported or to fight a CSEA case while he's incarcerated would have been close to impossible because he would have had to appear in some way, shape, or form.
Well, he could have filed motions. He could have, prisoners do that for say all the time. We get them all the time.
I understand that. but it would not have been an easy task for him to do so. I would state that even though he did not provide a lot of money, he was trying. He did do $12.23, which is a substantial portion of his actual income. And I'd ask you to look at the definition of income and realize that he was giving a great deal of that. 25% of it every month went to child support. He could not control where CSEA then sent those monies, because that is something that CSEA determines at their discretion. That is all I have to say. Thank you.
Thank you. Thank you both for your presentations, your arguments to the court this morning. The court will take the matter under advisement. We will issue a written opinion that will in turn be sent to the parties. And you can also look on our website, in the Supreme Court website, where we release electronically. Thank you so much.